Good morning. We'll just wait a few moments to let everyone in from the waiting room, and then we'll get started. As they're trickling in, I'll get started with the preliminary remarks. Just a few housekeeping notes. Please remember, if you can, to please stay muted. I think you all know where the mute buttons are, but that is helpful to us to avoid background noise. A reminder that this Zoom is general information. It is not legal advice, so make sure that you're taking it in that spirit. And if you have questions, please put them into the chat function. And Chelsea's put some notes in there already this morning. We have a light load of questions this morning, so we'd appreciate any questions. Ken may have to leave earlier than the end. We're not sure, but if you want to stick your questions in the chat that come up to you, that'd be great. Just a reminder that the chat function is not intended for legal conversation or legal advice. It's just for questions and helpful information for us, the presenters. A reminder that the Corporate Transparency Act, the CTA, is still being challenged by the National CAI, and we're still recommending that people wait a bit until later this year to work on compliance with that act. We've also been reminding folks that there were a number of revisions to WUCIOA that took effect last week on June 6th. So if you are a WUCIOA community, you should be aware of those changes. The revisions are not currently available. Last time I checked on the statute online, but there's a little hypertext link there that you can click and it'll bring you to the bill that shows you all the changes that were made. And hopefully they tend to update those a few months after they go into effect. So we'll keep checking. We are not having a Q&A next Wednesday, June 19th, so mark your calendars. We will not be having our Q&A next Wednesday, and then we will also not be presenting a Q&A on July 3rd. I think finally, Valerie's been reminding folks that there is a WSCAI Diversity, Equity, and Inclusion webinar on June 20th. If you're interested, go to the WSCAI website and you'll find a link to that program. And I think, Ken, unless there's anything else you can think of, we should get started.
No, just go ahead.
Okay, great. The first question, in a single family HOA, we're wondering if it would be okay for the covenants to prohibit unregistered vehicles only for the purpose of helping the board weed out junk vehicles, but without the administrative burden of tracking every vehicle each year. I think we're missing some information to thoroughly respond to this question, but look at your governing documents and see what you're allowed to restrict and prohibit. You also probably need to talk to your attorney about this. And also there's a lot of questions about, are the streets owned by your association? Are the streets owned or run by your municipality? If they're the municipality, you may have trouble enforcing on your end, but that may be something that the city may be able to enforce. This may be better managed in something like your rules, where you are able to govern the appearance of yards, the appearance of weeds, siding, things like that. You may be able to say, no junked vehicles in your yard or something like that. It may be simpler to enforce it that way. And it's not a question of whether or not the vehicle is registered. That is really, I think, your concern, and whether, and you're not really the correct enforcing body for that. It's probably more of an appearance of what the vehicle looks like or where it is parked that is probably a concern. So controlling or enforcing behaviors around where that vehicle is located or parked may be more what you're after. And so I think you may want to talk to your attorney about that, or craft some rules if you're able to, that may govern where things can be located and how they can look. Ken, any additional comments on that one?
I would just add that it's okay to have something which the association has the right to monitor, but not an obligation. So we have a number of clients which require that owners buy insurance, or require that owners submit a registration form every year. And the obligation of an owner to do that does not create an obligation for the association to have to actually collect all the information every year. So even if you did have a rule about vehicles needing to be registered and reported to the association, the association could still selectively try and determine whether or not cars are registered and enforce it that way. So, next question. Our condominium will be hiring a contractor this summer to correct major crawl space drainage issues in one of our common buildings. In addition to the state required insurance coverage, are there other types of insurance we should consider requiring the contractor to obtain? We're expecting the cost to be between $25,000 and $35,000. So there are, I'll say, a bunch of issues related to contractor insurance. And part of what you're looking at is not the value of the work which is being performed, but the value of the property which could be damaged, or, you know, how much could the contractor do in damage to your building or your property. And that's what you're trying to get insurance for, not just the cost of the work. So it's worth talking to your own insurance agent to make sure that any damage caused to your building is covered by the association's insurance to start. And you may want to talk to an attorney about that as well. There are requirements in your documents for insurance to be carried by the association to protect the building. Those usually do not address a contractor's insurance. Okay. One of the things which does happen is for licensed contractors in Washington State, they are required to have a bond with the Department of Labor and Industries, and they are required to buy liability insurance for damage which they cause, and that has to be registered with the Department of Labor and Industries. You can go to the L&I website, and there is a contractor verification page, and you can look up the name of the contractor which you're considering. It will tell you if they have the required bond or how much of a bond they have posted. And it will tell you how much insurance they have and the name of the insurance company which they're using. In Washington State, the amount of the bond which is required for a contractor today is either $6,000 or $12,000. Now, it does increase on July 1st of this year to $30,000 for general contractors and $15,000 for specialty contractors. But these numbers are really, really small compared to the value of the work most condo associations are doing, and really small compared to the value of the property which the condominiums are in control of. And so it's worth remembering that this bond is unlikely to be able to satisfy any claim you may have against a contractor when you are hiring a contractor. In order to make a claim against the bond, you are required to file a lawsuit in Superior Court. And this one bond is going to cover claims by any and all customers or other parties against this contractor, not just yours. It's not $30,000 for each claim, it's $30,000 total. The state's minimum required insurance is also, in our view, really inadequate to protect associations. The L&I website reports that a contractor only has to have $200,000 in liability insurance and $50,000 for property damage insurance, or a combined $250,000 limit policy. We consider these to be totally unacceptable. We would typically ask for a minimum of $1 million of coverage for a general liability policy for any contractor. And then we run into the problems of contractors who have insurance, but they have exclusions which would prevent any kind of recovery from the association in the event of a loss. So one very common exclusion is a multifamily or a condominium exclusion, which basically states that if a contractor is doing work for a condominium association, there is no coverage. And you can still get a certificate of insurance showing that the contractor has insurance because the exclusions are not listed on the certificate of insurance. So you need to ask and get a letter from the contractor's insurance broker, or you need to actually look at the policy and make sure there is not an exclusion for multifamily housing. Condominiums are considered to be litigious, and so the insurance companies writing policies for contractors put exclusions in for work on condos. The insurance company's intention is that the contractors just don't work for condos, but the reality is a lot of the contractors don't have a clue what their policies say and what their exclusions are. It's also important for some kinds of trades to look at exclusions that may affect the work being performed. There are some roofing contractors that have what are called open roof exclusions, which means that if it rains during the course of the work being performed, where the roof is opened up for replacement, there will be no coverage for water damage from rain. There are exclusions for torch down roofing, where the torch down roofing has an open flame used to heat the material while it is being applied to the roof of the building. And so it tends to ignite fires. And so there are a lot of insurance companies which will put an open or a torch down roofing exclusion into the policy for the contractor. And we also know that there are some plumbing contractors which will have exclusions for using soldered copper pipe fittings, because again, it's an open flame being used to perform the work. And so the contractor's insurance will just exclude any coverage for that, even though the contractor may be performing the work. So it's important for any contractor that you're hiring to check the L&I website and make sure that they are licensed and have insurance. And then it's important to get information from the contractor to make sure that there are not exclusions in their policy for the work you're having performed and for the kind of entity which you are. Okay. And if you have a contract which is anything more than a minor maintenance where you're willing to accept the risk that you will get nothing for the money which you have spent, then we recommend that you have an attorney look over the contract terms. Contractors are notorious about putting forth contracts to clients which are incredibly favorable for the contractor and very risky for the association. Customers tend to not read the contracts, and when they show up on our doorstep because there's been some kind of a problem, we are faced with contract terms which we cannot provide any benefit to the association because they agreed to the terms of the contract that was presented to them. And that's true not just with regards to insurance, but with regards to payment terms, regards to change orders, with regards to limits on liability, so that contractors are essentially bulletproof, even if they've done something wrong. So if you've got a contract you're considering, we recommend you have it reviewed by an experienced attorney, and not just an attorney who understands condominiums, but an attorney who understands construction contracts, because that's really the more important aspect of it. So is there anything you want to add, Lisa?
No, I just, we discussed before that folks can look on the L&I website to see whether or not someone has workers' compensation insurance, how many people they're paying for, and whether or not that you may be able to tell whether or not they're subcontracting out their work to see if you need to look at additional insurance issues or questions.
Yes, I did forget that. You're correct. And it is important to make sure that your contractors do have up-to-date workers' compensation, because what you don't want is a person to be injured on the job and come after the association.
Next question. Does Washington state law have requirements for handicap parking spaces for a condominium association, such as the number of spaces based on some factor like number of units? Does the Fair Housing Act address handicap parking spaces? We have all kind of thrown around the ADA as potentially impacting condominium associations, and that's generally not the case. The ADA covers mostly public buildings. So if your building qualifies, and that's something you may want to talk to your attorney about, there could be requirements under the ADA for having accessible parking, but that is likely not the scenario with most condominium associations. The building codes in Washington state, however, do have minimum requirements for accessible parking. It's more specifically, that's under Chapter 11 of the building code. So if at the time your building was constructed, under the building code, it was required to have accessible parking. That's still the case today. So it's not a case of looking back and saying, oh, we did have to have it then, but we don't now. No, if at the time your building was constructed that there was a requirement, then you are required to still have it. Generally speaking, or the building code states that one space is required if you have fewer than 26 parking spaces. 2 spaces are required if you have 26 to 50 spaces, but more specific information, you'll want to check out Chapter 11 of the building code. You may also need to look at your municipal laws and see whether or not your specific city has additional requirements or more specific requirements for your association. And then you also want to look and see whether your declaration has information about parking spaces, whether or not they're deeded or assigned to certain units, and what it says about parking information in general. We talked a little bit before that sometimes the building may have been required to have a handicapped or accessible space at the time of building, and that space was actually assigned to a specific unit or deeded to a specific unit, and making that space then not accessible or available to another person who may need it. So make sure that if you've got that could potentially be an issue. Ken had a story which you maybe want to talk about, that of an association where that happened. The board also might need to provide reasonable accommodations to an owner who needs an accessible spot. We've talked about this before in previous Q&As. You may want to look on the YouTube channel to see a more specific conversation about that. But if parking is assigned to specific units and as an owner is not able to use their spot but needs an accessible spot, the board could assist potentially in a conversation between owners looking at potentially swapping spaces for someone who needs an accessible spot. And it might be reasonable to provide one to someone if they do have an actual need, but talk to your attorney about that. And Ken, did you want to add anything?
Well, you touched on the need to accommodate if a person asks for an accessible space and meets the requirements for an accommodation. And the Fair Housing Act would require that you do that if the association has control of parking spaces. And you mentioned that you basically, if the space is a limited common element, the association can't do that. And the story I had was that at one point we had a client in Kirkland where the limited common element handicap parking space was assigned to a non-handicapped owner, and another owner wanted the space, so went to the city of Kirkland to enforce the parking regulations. And the city of Kirkland ticketed the car because even though it belonged to the owner of the space, it wasn't a handicap permitted car. So the difficulty was that no one was able to park in the parking space then, because only one owner had the right to park in it under the governing documents, but they didn't have the right to park in it under the city code for parking handicapped spaces, and the city was willing to enforce it. So I don't think anyone actually came out happy in that situation. And the city was insistent that if it was a handicapped space, it had to be used exclusively by handicap rated or licensed vehicles. All right, next question. If a board member wants to resign at a board meeting and several homeowners at the meeting are willing to step into the position to finish the term, does that board member get to vote? So I think the question is asking whether or not a departing board member gets to choose their replacement or gets to vote in the replacement. And the answer would be no. Once they've resigned, they have no voting rights at all. And until they've resigned, there's no vacancy to fill, so they can't vote to fill that. Certainly the remaining board members after the vacancy can do that, but the remaining board members do not have an obligation to fill the spot, even if there are volunteers at the meeting willing to take the spot. The board members that remain have the right, but not the obligation to fill the vacancy on the board. So, if the question related to voting otherwise, the new board member would get to vote if they're appointed on any issue that comes before the board as soon as they have been elected to the board. So did you have anything else you want to add on that, Lisa?
Nope.
Yeah.
Next question. Our association is about to initiate a reserve study. We're not clear if state law requires studies to cover a 3-year period or a longer 4-year stint. We'd be grateful for any information you want to share about reserve studies. The first thing about reserve studies is that they are a 30-year look ahead at all building components. And what the statute requires is that they be done annually. They only require every 3 years that a reserve study professional perform the study based on a visual site inspection. So it is possible for a board or an association to hire a reserve study professional to perform an initial visual site inspection, prepare the reserve study, which again looks at 30 years in the future. And then every year annually, a board member or another engineer or someone else updates the reserve study. But then at the end of that 3-year period, another visual site inspection needs to occur by a reserve study professional. So, and this applies to all communities. Everyone, every community that's out there is required, with very limited exception, to perform these studies. They do have to be updated every year because there are, everything changes. Costs of repair, expenditures of the association, and all the components, depreciation changes. So again, initial study by a reserve study professional with a visual site visit, then annual updates to cover the 3-year period, and then again, another visual site inspection at the end of that time. Anything I missed there, Ken?
You didn't cite the reference you had.
Oh, thank you.
RCW 6490-545, which is part of WUCIOA, applies to all communities. And so the standards for reserve studies in WUCIOA, which is subsection 550, are what need to be used for all communities, regardless of their age, regardless of their type. And as Lisa noted, there are limited exceptions for associations not getting a reserve study. And it basically is only if the association has no significant common elements, and the statute actually defines what a significant common element would be. Okay. Next question. If a construction company is doing major work on an old act condo building and they need several of the association's assigned parking spaces for scaffolding, pump jacks, or whatever, at least for several months, what authority would the condo association board have to reassign parking spaces such that enough are available to complete the construction work? Would a condo board have the authority to compel a selected number of owners to give up their parking spaces for months and simply have them find their own parking spaces elsewhere? So the short answer, without knowing all the details and without giving specific legal advice, is that the association certainly has easement rights and the authority to move people out of parking spaces in order to perform necessary repairs to the building. I think that it would be a poor choice to just advise those limited owners that they're just screwed and have to go park somewhere else. I think that the association should make some efforts either to swap parking spaces around so that people who are not using their spaces can give theirs up. We've seen clients where they will effectively rent parking spaces from other owners, or they will temporarily assign common element and guest parking spaces to the owners. My recommendation would be try and find a way to work out a solution with your owners so that people still can park. We have worked with clients where it was, I'll just say, virtually impossible to find adequate parking. And the contractors were also a party to the negotiations to try and make sure that it was predictable when the parking spaces wouldn't be used, or when they would be blocked by the contractor. So we would ask for cooperation first from the owners and look for solutions. Again, we've seen clients where they compensate the owners the value of the parking spaces. And I would say in most cases, there is a solution that can be worked out by negotiating between the client and the contractor and the individual owners who are affected. Did you have anything else you wanted to add, Lisa?
No. Do
Okay.
you have any questions in the chat, Chelsea?
All right, so first question. Is it correct that making changes to the CC&Rs in order to make them compliant with state law, e.g. WUCIOA for all, that the HOA does not need to subject those changes to a vote of the membership?
So I'll say there's a lot of confusion about what the statute, meaning WUCIOA, allows a board to do independently without a vote of the owners. And the answer is that if there is a conflicting provision, meaning WUCIOA has a requirement and it is different than the requirement in the governing documents, then the board alone can adopt a CC&R amendment. It requires 2/3 approval by the board. It requires notice and an opportunity to be heard for the owners before the board makes that vote. But it is limited to things which are truly different, a true conflict. So one example would be that old act condominiums right now can have amendments with as little as 60% of the owners, but WUCIOA requires 67% of the owners. So if the current declaration says you can do an amendment with 60%, that is a conflict with WUCIOA, and the board would be able to change it. But if the WUCIOA statute simply allows something and it's different than what your governing document has to say, you're still required to get the approval of all the owners to make a change. So if WUCIOA allows you to assess costs for misconduct by owners to the affected unit, and your governing documents do not do that, even though there's a difference in what the statute provides, you need to do an amendment with a vote of all the owners to adopt that additional privilege under WUCIOA into your documents. So Lisa, do you have anything you want to add on that?
No.
So Lisa, how would the super priority lien work for condominiums where the statute is providing 6 years, but the governing documents all say 3 because they were written under the new act?
That is a good question. I mean, my sense would be that the statute would be the one that would govern that, but I guess I'd need to look. I don't have a quick answer to your question, Ken. I'm sorry. What's your thought in asking?
My thought is that a court would pick the
The
provision which is most favorable to the debtor.
That's right.
And so even if the statute said there's a 6-year super priority lien, if the condominium document still said a 3-year super priority lien, I think the court's going to choose the 3 years.
Well, and the question is which one is actually more favorable too, because I sort of think it sort of depends on the benefit to the debtor as well, right? I mean, is it more beneficial to the debtor to have more of their balance paid? I don't know. But I
How
think you're
about
right.
the
I think it's
statute
probably
limit?
3.
How about this? Well, maybe I'm thinking statute limitations 3 years versus 6 years.
Right, right.
So-
Yeah, that's more beneficial than definitely 3 years.
And I guess what I'd recommend is for something like that, if you're looking to make other modifications to your documents, whether it's related to insurance or maintenance of windows or anything else, that you would go ahead and adopt the favorable portions of WUCIOA, like moving to a 6-year statute of limitations for condos and adopting the super priority lien for single family home communities, because those are absolutely no risk to the community to adopt them. And they should be easy to get the votes for if you can just get people to participate in the vote.
And 6 years would sure be great for the statute of limitations on a lot of associations who have delayed referring their files out to attorneys to collect.
Anything else, Chelsea?
Yes, next question. Our association is a POD/HOA, not a condo. An owner is selling and his buyer has requested a resale certificate. I know these are required for condos, but my understanding, they are not required for HOAs and our declarations do not require it. If requested, is the association required to provide one? The description of a resale certificate includes items that don't seem to apply to our association.
Well, I'd want to see specific documents to give legal advice. I would say generally that until WUCIOA is taking effect, single-family home communities do not have a requirement for a resale certificate. There is reasonable information which the association should provide, which would include things like how much the dues are and what the balance sheet for the association looks like. And so the request for a resale certificate is not an unreasonable way for a prospective purchaser to ask for information. And so I'd probably want to find some way to provide the information so that the sale could be facilitated, because generally I think that's favorable to the association to do. But is there a legal requirement for a resale certificate? Not today that I could determine. Is there a legal requirement to provide information? Yes, I think there is, even if it's not stated as a form of a resale certificate. Any thoughts on that, Lisa?
Yeah, I was going to say that the statute that the person references is 6434, so that's referencing condominiums. But also that I have seen in some governing documents, some declarations do require something like a certificate of assessments or something like that. So it might not be called the resale certificate in your documents, but there may be a requirement to provide information in your governing documents that might be called something else. So again, as Ken said, it's probably a little more specific than we're prepared to answer, but there may be a requirement in your documents as well.
Yeah, generally there's 2 kinds of information that are important on the sale. One is the financial stuff. Has the owner paid all of their past due assessments? Because you want to make sure that when the unit sells, any unpaid assessments are paid to the association in the transaction. So you want to give information to the buyer to make sure that the association is made whole. And then the second set of information, it relates to restrictions and obligations for the property. So you want to make sure that a prospective buyer has copies of the rules and regulations and the covenants and architectural control requirements and everything else, so that you don't end up with a conflict after the fact where the owner's trying to do something which the community is prohibiting. So, we think it's valuable to the association to communicate this information. Anything else, Chelsea?
Yes, there are a couple of follow-up questions related to resales or to reserve studies. The first, Are all building components required to be in the reserve study regardless of who is responsible for the cost of replacement, owner or association? And also, what happens if an association never had a reserve study?
I also see a question about what certifications are required to be a professional reserve consultant.
Well, we'll start with that last one. The qualifications defined in the statute to be a reserve study professional are that you are by training or education qualified to be a reserve study professional. It's circular logic with no help. So pretty much anyone can claim they are a qualified reserve study professional. In regards to the components, I believe only components the association pays for need to be included in the reserve study. Because if it's a expense which the association does not pay for, then there's no reason for the association to save money for it. It wouldn't be included in the reserve study. So if you're talking about windows and doors, which for many condominiums are unit owner responsibility, it'd probably be useful for owners to know how old their windows are and when they might be replaced, but they do not calculate into the math for the reserves requirements. If you are a single family home community, but the association paints the exteriors and re-roofs the buildings, then it may be the only components you have are roofs and painting. And it's fairly common for us to see communities where paint and roofing are the only two components which the association handles. So I think the answer is you just include in the reserve study those components that the association maintains and pays for. And I'd have to see the specific documents for a community to be able to advise further on that. And also I'll comment that we see reserve study professionals screw up their reserve studies frequently by either ignoring a component which needs to be paid for, like the plumbing system, or including components which do not need to be paid for, such as windows and doors. So.
And if an association has never had a reserve study, Ken, what the questioner was what happens? And I don't know if that there's a what happens, but what could happen.
So the statute provides a remedy for a community that does not have a reserve study. And that is that if 20% of the owners sign a petition demanding a reserve study be performed, then it has to be included in the budget for the following year. And if the budget is ratified, then the association has to perform the reserve study. I'm not aware of any other penalty for a failure to have a reserve study.
I mean, because they are required to be included in your budget packet to owners, it also becomes a risk, right? I mean, if someone wants to buy into the community and they see that, or, I mean, it's basically telling owners, we don't know what's going on here.
Well,
it's a practical risk.
But there is in the statute a specific statement to be included in resale certificates, which states to the owner or the prospective buyer that there is no reserve study and that creates risk for them as a buyer. And there is the ability on the budget process to simply state, no, we don't have a reserve study, which also means there is additional risk to the owners because they don't have enough information to accurately predict future expenses. Anything else, Chelsea?
Another reserve question. We have stormwater wet vaults that are major expenses, typically only requiring cleaning perhaps every 10 to 20 years. Would you recommend including that in a reserve study?
The answer would be absolutely yes. The definition in the statute for what should be in the reserve study essentially includes any kind of maintenance or repair or replacement which occurs less frequently than every year. Because if it happens every year, it goes into your operating budget. And if it's going to occur within the next 30 years. So if you're telling me you're going to clean the vaults out every 20 years, they ought to appear in the reserve study at least once and maybe twice, because you're predicting expenses 30 years forward.
Any other questions, Chelsea? I don't see any come in. I did see a comment that someone said that their study didn't include things like caulking around the windows every X number of years, and the past boards only did what was on the reserve study. So now they've gone 20 years without anything done about the caulking on the windows, and there's water intrusion. So it's a cautionary tale.
Well, whether you call the caulking part of the paint job or not becomes one of the questions. And most people mistakenly believe the reserve study is a maintenance plan. And they often believe that the reserve study is an evaluation of their building envelope. And in most cases, reserve studies are not maintenance plans. They are a budgeting tool. And in most cases, the person doing the reserve study is not qualified to evaluate the building envelope. So I often tell people to think of the reserve study in the same way they might think of health insurance. You have, if you were an employer and you had 50 employees or 25 employees, you can make predictions about how much money it's going to cost to pay for the health care, even though you don't know exactly which person is going to get sick or when, and you don't know what they're going to have happen to them. The same is sort of true with the budgeting or financial planning tool for the reserve study. You've got a bunch of building components that you can identify, and you have some ability to predict how long they might last. And based on that, you can predict a dollar amount, and you're collecting the dollars so that when the events occur that require replacement, you have money in the bank, in the same way that under the health insurance, you are trying to collect enough money that when somebody gets sick, there's money to pay for their medical bills. Okay? And with your employees, you would use age and gender and whether people smoke or not as predictors of how much money you should be saving for their future health costs. And that's the same thing the reserve study professional does by looking at the kind of roof you have, the age of the roof, and they're making predictions about how much money you might need. But the fact that the reserve study might say you need a roof in 2026 does not mean you need a roof in 2026. You might need a new roof today, and it might be the roof could be, tacked on or patched and last another 5 or 10 years. How you maintain the building is going to affect how much money you actually need. And that's different than what the reserve study is going to say. We also know that frequently when an association goes out and hires an engineer to deal with a building envelope, the cost of repair comes in multiples of what the reserve study had predicted. So the reserve study might have predicted that replacing the roof and siding and windows will cost $1 million, and the contractor's quote is $3 or $4 million. And it's because the scope of work which the reserve study professional had imagined was going to occur is very different than what the architect or engineer has specified. And that becomes a real problem for a lot of our clients.
Any other questions, Chelsea?
Nope, that's it.
All right.
I think we're done early today, everyone.
Yep.
Thanks very much. And a reminder, no Q&A next week on the 19th.
All right. Bye, everyone.